Okay, sorry. I think I had ended the other one, the last lecture video, by saying we were on to part three. I got a little ahead of myself. We're on part two, and we're just going to finish talking about mistrials. So, a mistrial does not fall under double jeopardy. Um, all right. So, on appeal, the case is the trial has been completed, sentencing has been completed, and now the defendant has submitted the case or a motion to the appellate court saying that there were errors and that the errors were of a nature where the case needs to come back. So all the cases that we read in our book, these briefs that we're doing, or most of them, 99% of them, were cases that came back after an appeal. So cases returned on appeal, jeopardy does not attach. Two things can happen generally. The case will get sent back because the appellate court needs a clarification in order for them to make a decision, or the appellate court will make a ruling and send the case back and say, okay, now that we've given you the rules to follow, go back and make a decision on whether it's a sentencing issue or whatever the issue is. And then the third option is they will send it back to either dismiss the case or to tell the trial court to start over, to do a new trial. The last trial is no good and they have to start over. So you'll see sometimes where prosecutors will get a case back on appeal and make a decision not to go forward because evidence has been destroyed, witnesses are no longer available. For whatever reason, they cannot go forward with a new trial, and so their hands are tied and they'll have to dismiss. Or they may take the appellate court's decision and say, yeah, we agree with the appellate court. This case should be dismissed. That doesn't happen that often, but it can happen. All right, so the defendant has a right to be present at all court hearings. So we talked about them having a right to an attorney at all critical stages. The defendant has a right to be present at all court hearings. So that means that anytime they go on the record, the defendant has to be present. Now, the defendant can waive their presence. If they waive their presence, and I've seen this happen a few times in my career, where the defendant just doesn't care, or they feel that they're being railroaded, and so their form of protest is just not to show up. And so the court will have the defendant go on the record and say, you know, I understand I have a right to be here, but I give up my right. And no one's pressuring me to give up my right. I'm just openly choosing to give up my right. And then the court will make sure that it's a knowing waiver, that it's an intelligent waiver, and that the defendant is not being forced to stay out. Now, the court can remove a defendant from the courtroom if the defendant is being disruptive. Most of the judges I know are very slow to move a defendant out of the courtroom. Some of them, in my opinion, are too slow. I've had a few judges that don't take any kind of disruptions from the defendant and they'll kick him out right away. Some of it has to do with the temperament of the court more than the defendant. But generally, judges are pretty slow to have the defendant removed out of the courtroom, but they can. Usually, they'll admonish them first. They'll say, "Look, if there's another outburst like this, if you violate the rules one more time, I'm going to have you removed from the courtroom." If they do remove them, oftentimes they'll bring them back either at the end of the day or the very first thing the next day, and kind of give them a new chance. They'll say, "Okay, I want to bring you back. If you're disruptive again, I'll kick you out." And so they want to give the defendant a chance to be there to help their defense attorney in their case. There's different rules for misdemeanors and for felonies. Misdemeanor cases, the defendant is not required to be in the courtroom. And so oftentimes you'll see with misdemeanors that a defense attorney will show up. Even if there's a change of plea, the defense attorney will show up, and the defendant does not show up. On felony cases, the defendant has to be present. In fact, if the defendant's not present in the felony cases, a warrant will be issued for them. Now, the defendant can ask the court permission not to be present. but the defendant has to be present to ask for that permission. Rule number one, they have to be present and say, Judge, on the next set of hearings, I don't want to be present. So I've seen it a few times when you have a defendant that was charged with a felony and they now moved it out of state. I had one case where the defendant had moved to Utah. And so on the first hearing, the defendant appeared and said, Judge, I'm living in Utah. The person was out of custody. And so the defendant was asking not to be present for all the pre-trial hearings. And the court allowed them to do it. They signed a motion promising to be present at certain hearings. And the court would say, okay, at the preliminary hearing, you have to be present. But all these pre-trial hearings, you're not required to be present. So in felony cases, the defendant must be present. They can sign a waiver, but they have to be present in court to ask for permission not to be present. I know that sounds confusing, but they have to be present, physically present in the courtroom and say, Judge, for all these pre-trial hearings, I'm asking that I have permission not to be present. And the court will generally grant that. If they have, for instance, transportation problems or logistically they live out of state, the court will allow that to happen. And it's done by written motion. All right, so the defendant has a right to a public hearing, meaning that the court has to stay open. So if you have a trial that's going on until 7 or 8 o'clock at night, the entire courthouse, meaning the main entrance and that particular courtroom, have to remain open. So the public has to have access to the courtroom. The courtroom can be closed to the public in some situations. So if there is a margin hearing, for instance, the court will order the courtroom closed. I've seen judges order the courtroom closed during jury selection. When I was doing sexual assault, oftentimes people would want to come forward, potential jurors, and say, Judge, I can't be part of this hearing because something bad happened to me as a child. And the court will close off the courtroom so that just that individual's in the courtroom and the staff give the person some privacy while they talk about some very sensitive issues. So there are times when the court will close the courtroom, but not that often, and the court has to be able to justify its reason for doing so. But oftentimes the court will seek the permission of the defense attorney in closing the courtroom, and oftentimes the defense attorney is asking the courtroom to be closed. Witnesses can be excluded. It has to be by motion. So if it's a very common motion, defense attorneys and prosecutors make it on a regular basis, almost every trial. They'll say, Judge, I'm going to make a motion. It's a verbal motion. They can just say, Judge, I'm making a motion to exclude witnesses. Judge will grant it. Children can be excluded. Oftentimes judges don't want children in the courtroom, so you can kick out kids. And anytime anybody's disruptive, they can be removed from the courtroom. And I've had that happen. I've asked the court to remove individuals from the courtroom during trial. It does happen. All right, the Sixth Amendment requires that the defendant has a right to confront witnesses. What that means is the defendant has a right, if somebody's going to testify against the defendant, then that person has to be present in trial. And remember when we talked about admissions and confessions, and we talked about Aranda Bruton, this is where that challenge comes up. So if I have two defendants and one is not made a confession, you can't get that confession in against the other defendant unless the person who made the confession gets on the witness stand. And so oftentimes you'll be forced to do two separate trials. Out-of-court statements made by a witness are inadmissible unless there's some exception to the rule. That's your hearsay evidence. So this is not a class on the rules of evidence, but we hear all the time in shows and movies about hearsay. And hearsay, the definition is a hearsay statement is a statement, an out-of-court statement made or offered for the truth of the matter, meaning that you're offering the statement to prove a piece of evidence, and the proof is the statement itself. So, for instance, if you were to if somebody yelled, "Oh my gosh, that white car just hit that little old lady," that statement could only come in at trial, if it's irrelevant, by the person who saw the white car hit the little old lady. So if I'm standing on the corner and I hear someone yell the statement about the white car, I would not be allowed to testify if the purpose of the evidence was to prove that the car was white. So you can have out-of-court statements if it's not to prove what the statement says. Like you can have an out-of-court statement come in to show the person's state of mind or to show their emotional state. You know, um, you know, uh, maybe an issue at trial was the victim. You want to show that the victim was in fear of their life, and so a witness would come in and say, "Yes, I heard someone screaming, put down the knife, put down the knife." That would be an instance where you're not offering it to prove that there was a knife being used, but you're offering it to show that this person was in a hysterical state or one where you could interpret as that their life was being threatened. So out-of-court statements can be used, but generally, if you're using the statements to prove the content of the statement, then the person has to testify. And then the defendant has no right to question witnesses on the stand. So only the defense attorney can ask questions. The defendant does not have a right to ask questions to witnesses on the stand. If the defendant is representing themselves and they are going to have to ask witnesses, for instance, in a domestic violence case, where there's a relationship, a sensitive relationship between the person testifying and the defendant, oftentimes the trial court will hire an attorney solely for the purpose of cross-examining the witness, like the victim of a domestic violence or a victim of a rape. And then they're not going to allow the defendant to ask the questions to that individual because it raises a lot of other issues of intimidation, threats, fear, etc. Okay, so the preliminary hearing. Preliminary hearing is a pretrial hearing. It is required in felony cases, not in misdemeanors. It is written into the Constitution because King George did not have preliminary hearings. The preliminary hearing's purpose is to protect the individual from unreasonable detentions and being held unreasonably by the government. So the law says that once you're arrested and you're detained and you are in custody, the prosecutor has 10 days from the date of your arraignment to have a preliminary hearing. So it's a court trial, and the standard of proof is far less than beyond a reasonable doubt. The prosecutor has to prove that a crime was committed, and more than likely, this person is the one that committed the crime. Now, the rules are a little different. The prosecutor has to put on witnesses. The prosecutor can put on limited hearsay evidence. So if you have a robbery in a bank and you've got 7 people that were robbed, instead of taking 7 people away from their work and forcing them to sit in a courtroom all day for the preliminary hearing, if there was an officer or officers that interviewed these people, you can bring the officers in most cases, and have the officer testify that that they interviewed this person and that and then the officer can repeat what the person said. And the reason this is allowed is because the purpose of the hearing is not to prove the case beyond a reasonable doubt. The purpose of the hearing is to show that a crime was committed and that this is the defendant that more than likely committed the crime. So because the standard's different, the court does allow some hearsay evidence. Let's see, the court must decide, okay, so it has to decide whether more than likely the crime was committed and whether more than likely this person's the one that committed the crime. Defendant has a right to waive the preliminary hearing. Most defendants do not. Periodically, they will waive a preliminary hearing. But by law, it's required. If you miss a date on the preliminary hearing, the case has to be dismissed. So that's the remedy. So timing is very important. Okay, so this is part 2. We are now going to go to part 3. And yes, this will be the last video lecture that you have to suffer through for the semester. So I will see you in just a few minutes with part 3.